Okay, this is take two for Simon. Simon Parker has been the Prosecutions Officer for Brimbank City Council since 2011. Prior to this, he's worked in various positions at the Hume City Council from 1998, including parking, animal management, local laws, and as a fire prevention officer at the Brimbank City Council. Simon has presented matters at the magistrates, the county, and Supreme Courts, as well as preparing matters and giving evidence in the VCAT tribunals. This role has led to his interest in thorough and detailed investigations, as well as a desire to ensure that when officers are required to attend court to give evidence, they are actually really well equipped to ensure that the best possible result is obtained. So please welcome Simon Parker.
Good morning. I'll start off by saying this is not going to touch on individual legislation from different jurisdictions. It's going to be a presentation that can be taken back to any jurisdiction, and the principles that are up here, they actually do work. They will get you success in court. Another thing, you won't have a very angry prosecutor chasing you out of the courtroom wanting to know what the hell you've just done in the courtroom. Okay, so there's no legislation to be touched on, because quite frankly, if you're going into a courtroom and you're still worrying about a particular piece of legislation, it's way too late. That should all have been done during investigation, so don't worry about it when you get to court. These two officers just found out they have to give evidence in court, and that is a reaction that I see all the time. People have this stigma that I'm going to give evidence in court. They view it as the Magna Carta, and that they're going to have thumbscrews put on and be put under all this undue pressure. At no time am I going to tell you don't be nervous going to court. I've been doing it since 2004 and was giving evidence prior to that. Since then I've been at the bar table and prosecuting matters. I still get nervous whenever I go to court. I'm in court 3 Fridays a month, and every day I still have a batch of nerves walking into that courtroom. If you don't have nerves before your case, that tells you two things. It tells you, number one, you don't care, and an officer who doesn't care about the outcome of what they're about to do and doesn't to some extent have a vested interest in what's going on probably shouldn't be there in the first place. And number two, if you're a bit nervous, you perform better. If the nerves are gone, you become blasé, it becomes second nature, you're running on autopilot, and your best outcome doesn't get achieved. Your best performance doesn't get achieved. And I'll use the word performance a lot because, as the title suggests, putting everything aside about scales of justice and finding people guilty, not guilty and penalties, going to court is nothing but a show. Okay? It's a show that comprises a couple of different aspects. It comprises the evidence. Another big aspect of all shows is the actors. And you as officers take the roles of the actors in court. And it is very important to remember that at all times. The one thing that covers every jurisdiction in Australia, and not sure about New Zealand, but I'd be surprised if it didn't, is the idea of the model litigant. This is something that is at the level of Attorney Generals across the state and in the Commonwealth. Local government is a government body, and they are held up to a very high standard. You are to be the model litigant. If a case is to be done a certain way, if evidence is to be presented a certain way, you are held to that regard. We've all been in court and we've heard defendants give evidence, and quite frankly, sometimes it's funny with what comes out of their mouth and the way it's delivered. Never lower yourself to that level. Your level is to be so high above that that it's not funny, and when they say model litigant, they mean exactly that. And a lot of cases I've been involved in, that comes up. Particularly ones at VCAT with regard to restricted breeds and the subsequent Supreme Court stuff that led to. The words model litigant came out all the time, and it is something that you need to remember at all times. Just a couple of terms to go through, just so, number one, it takes away the mysticism of court and people aren't so nervous about court, but they're terms you've all heard before, so they shouldn't be anything that daunting. The idea of reasonable doubt, that's the level we're working towards with our prosecutions, with our court cases, reasonable doubt. and it is exactly that. You have to prove your case to an extent that that defendant can't come up with something plausible that could be an alternative. Okay? And it is only there so that you're aware of it. When you get in the witness box, that shouldn't be anything you worry about, because you are there to give your evidence. It's evidence you should know fairly well before you get in the witness box. You shouldn't be couching it in such a way that you get to reasonable doubt. That's the job of the prosecutor when they structure a case. Your job as officers is purely there to relay the evidence and information you've obtained during the investigation. Reasonable person, that is the test of what evidence is put up against. Can a reasonable person in knowledge of all the facts come up with the same decision that the magistrate did? And the magistrate is the only reasonable person who matters. For most of a court case, he is the only person that should exist in that room. And his level of reasonable is the only one you should care about. Magistrates have different levels of reasonable. Some magistrates are great. As I said, I appear in court 3 Fridays a month. I've got a relationship with some of the magistrates that if I'm down the road when I'm not in court attire, he'll come up to me and say, I look like shit today. Under no circumstance would I turn around to him and say, I look marginally better than he does. The relationship is not like that. His level of reasonable is totally different to another couple of magistrates we've got down there who I don't think have a reasonable bone in their body. They exist purely on the realm of legislation and don't go beyond it. The difference between witnesses and informants. You can fall into both categories. In most cases, you will be the informant. So your evidence is the structure of the case. The nitty-gritty comes from the witnesses. They saw it, they did it, they heard it, they witnessed it. You give the overall structure of the case. It's through your evidence that you know that you can tick off the points of proof you need in a structured fashion and lay it out before the magistrate. They love structure. They don't like to think about things too much. If you lay it out structured in front of them and they know, right, I'm going to hear this, this and this witness is going to tell me that, job done. They're in a mode to be listening to what they're going to hear. This talk probably could have been summed up pretty quick if I just showed you one slide, and this is the slide. This sums everything up with going to court. It is the golden rule. If you take nothing else away from today, remember that as gospel. That is what it is all about. It is about respect. Respect the process, the parties, the institution, and probably most importantly, respect yourself. And always remember that judgment starts the minute you walk through that door. Your case might not be on for an hour, and you may walk in the door and think the magistrate is asleep when you do walk through the door. They miss nothing, and their judgment of you starts the second you walk in a council uniform. They know what their list has got on for the day. They know there's council matters coming up. They will be starting to judge you, the type of officer you are, the type of person you are, the second you walk through that door. It's not something we sort of build up to scare people. It's the truth. Magistrates have told me that all the time, that officers gave evidence, they listened to the evidence, but there was just something about the officer. It might not be something provable under legislation, but as I said, the magistrate's the only reasonable person that counts in that courtroom, and they can entirely justify a decision made in a case based on the believability of witnesses and informants. So breaking that process down into respecting the process. That top one, be prepared. Know your evidence. When I take officers to court, they've built a brief, they've presented it to me, we've gone through all the process. I can guarantee to every one of those officers that I know what they're going to say. I've read through the brief. I expect them to do the same thing, that when they get in the witness box, don't take it for granted that you have a sheaf of notes for your investigation and the magistrate's just going to say, okay, jump in the box and start reading. As a rule, they don't like that. They want you to exhaust your memory of the incident before you refer to your notes. And the permission, and it is permission to refer to those notes, comes from the bar table. That's why I like to know the case and I like to know how much my officers know about the case, because then I can be prepared to ask that question to a magistrate. And it's along the lines of, Your Honour, the witness has exhausted their memory, can they refer to notes which were taken at the time and contemporaneous? Magistrate has a choice, yes or no. That yes or no can be based on the judgments they started making the second you walk through that door. If they think you've walked through the door half-assed, they can and they will say no, and they will leave you hanging out to dry in a witness box, umming and ahhing because you can't remember stuff. And the investigations are pretty involved. We don't expect you to remember everything, but we expect you to remember the important stuff, the big ticket items, and the intricacies of that can then come through a reference to notes. The second one sounds pretty simple, but I've heard a lot of officers get caught up with it. There is nothing wrong if you're asked a question in court and the question goes on for 3 minutes. There is nothing wrong with your answer being yes. There is nothing wrong with your answer being no. The problem is you might be in the witness box and the defendants represented themselves. They get up and they say, Officer Smith, did you see my dog in that street and did you see my dog bite that person? You were lucky you were on the scene. The answer would be yes. That's it, simple as that. The answer would not be, that dog was there. You don't explain it, you don't go on, because you're just looking like you don't know what's going on. The answer is yes. You asked me, I saw it, I've answered it. Keep the questions very simple, because every time you go beyond a yes, that gives them something else to come back at. There is nothing wrong with yes or no. The other point is, while you're waiting for your case, as I said, you might arrive to court at a certain time, you might not be on for 2 hours. So you either sit in the courtroom or sit outside the courtroom. If you sit inside the courtroom, don't look bored. Because while the magistrate's hearing this matter over here, they're still glancing at you. And if they look at you and every time they look up, it looks like you can't be bothered being there, that gets slotted in the memory banks. And when your case comes up, you're remembered first off as the bored bastard from the back of the courtroom. Then you have a hurdle to overcome before you even start in the witness box. You don't want those hurdles to overcome. You want to arrive there with that magistrate already having a good opinion of what he's about to hear. This one's one that causes a lot of officers a lot of difficulty, respecting the parties involved in the court procedure. Respecting your prosecutor, your lawyer should be fairly easy. Respecting court staff should be fairly easy. The other person up there, which is difficult a lot of the time, is respecting the defendant. You've just gone through an investigation on a dog attack, and during the investigation, that defendant has been the biggest ratbag son of a bitch ever. He's denied, he's lied. You've got your brief of evidence and you're presenting it. You can't afford for that baggage to be brought into a courtroom. You present your evidence impartially, and it's not easy. You present it impartially and let the one important person in the court make the decision. And if you present your evidence impartially and it's good evidence, that magistrate will come to the same decision you have, that the defendant is guilty. Your personal opinions need to be kept out of it to a massive degree, because that is the problem a lot of officers have, and it turns into the level of respect starts up here. By the end of a court case, it's down here and it's turned into a backroom brawl at the local pub. Magistrates will not accept that, and cases have gone down because of it. And defendants can represent themselves, particularly in Brimbank. We have a lot of people defending themselves. They don't get lawyers. They have the opportunity to ask you questions. They have the opportunity to cross-examine you. They can challenge you on your evidence. Again, answer questions succinctly. Yes, no. If they ask for an opinion on something and you're not in a position to give that opinion, chances are your prosecutor will be up from the bar table before you can even think about the answer, and they will be objecting on your behalf. In my court cases, I gauge my objections on the officer concerned. If I know the officer I've got in that witness box is fairly good at their job, is fairly well prepared for court, I may let things go a bit further than I would for someone who isn't that well prepared, is nervous about court, it might be their first time. I protect the witness as much as possible, but I don't go to the extent of protecting the witness that the magistrates is then starting to think, what's going on here? You seem to be a bit cautious with this one. So it comes down to those sort of things. Again, don't argue with them. There's no point having an argument. The whole case is the argument. That little one individual argument you have with that person cross-examining you is not going to win you any points. It's not going to sway the magistrate. The evidence will sway the magistrate. And evidence well delivered will win out every time. The other point is conduct yourself professionally towards that other party at all times. As I said, magistrates miss nothing. When you're sitting in court, if a snide comment is made, they will pick it up. If a filthy look is given, they will pick it up. You get plenty from the other side. As I said, the idea of a model litigant. You rise above all that and you set yourself well above the crap that the other side can quite often bring into a courtroom. This one, respecting the institution. A lot of officers, this is part of the mysticism of court. They walk into court and they see people bowing at things and doing this, and some of the responses given to questions are a bit, oh, what's that going on for? But that is the one thing magistrates look out for. You might not know they're watching, but if you enter a courtroom and don't bow, if you've copped a magistrate on a bad day, he will order you out of his courtroom. If you've copped him on a moderately bad day, he will just remember it until your court case comes up. You don't want to be arriving in the witness box already behind the 8 ball. Do everything you can to be ahead of the curve before you get there. The other thing is, in court, talking is allowed. It's to be done in a whisper, it's not to be shouted across the courtroom. But one thing that magistrates, police, prosecutors, officers of the court really crack it about, when someone is making the oath in the witness box, do not move, do not talk. That is one of the most solemn parts of a court proceeding. That is the bit where this person is promising to the world, the magistrate and God, that they're going to tell the truth. It is a very important part of the process. Magistrates hold it to the highest regard and they expect everyone else to. Normally in magistrates' court, the clerk of the court will lead you through the oath. I can guarantee you, you will win brownie points with every single magistrate out there if you know the oath. If you can get in the witness box, grab the Bible if you're using the Bible, or affirmation if you're using an affirmation. If you can run that out verbatim, a magistrate will have a very high opinion of you. It's only something small, but it's little things like that which will keep you ahead of the curve. So I would advise everyone to get to know that oath. It's not a big one, and it will help you in the eyes of the magistrate. The other one's fairly simple. Being early is being on time. If your court case is on the books for 9 o'clock, you arrive at court before 9 o'clock. You will then sit there on your bum and you will wait till about 10:30 when they finally get through all the rigmarole. There's a lot of waiting involved, but as far as being on time, it is early. If it says 9 o'clock, don't arrive at 9 o'clock thinking you're the best thing in the world. Being early is being on time. And in a courtroom, for those of you who've been there, bar table, cattle class sitting behind there waiting for their case, court staff, magistrate up the front, you're being cross-examined from over here. Don't have the conversation with this person over here. The one person, the reasonable person in the room who needs the information, the one person who needs to know the stuff is sitting up the front. Direct all your answers towards the magistrate. So a lot of people will ask me, oh, isn't that rude? Because he's asked me the question. No, it's again another aspect of respect, that you're recognising that that magistrate is the most senior person in that room. The fate of what you're doing is in his hands. Direct all your answers towards him or her. Some magistrates will run their courts to such a degree in terms of what some people might call political correctness of court, that if you don't look at them and don't direct, they will pick you up on it. And they will say, oi, I'm over here, I'm the one you need to talk to. You don't want that to happen. Last one, or one of the last ones, is respect yourself. When you're out doing the job of an animal management officer, you wear a certain uniform which is designed to the best effect of being an effective animal management officer. When you're in court, that's not the uniform you wear to court. I'm wearing a suit today, not because I like wearing suits to conferences in Townsville. This is what I wear to court. This is the respect I show the court when I'm there. On days when the air conditioning craps itself at Brimbank Court and it becomes 35 degrees in a stinking courtroom, the jacket doesn't come off. I'll sit there and I'll suffer. That is the respect for the courtroom, and that is something any of my officers go to court, the first thing they get told is tie is a minimum, jacket is preferable. Because even prosecutors have been chipped about not wearing jackets when sitting at the bar table. Professional language, don't get into jargon, don't get into slang, anything like that. Keep the language professional because you're dealing with a professional magistrate. Don't worry about him not understanding it because I guarantee you they will. The other thing is be honest at all times, which sounds like a pretty simple one. As I said to you before, I know my briefs better than the officers do giving evidence by the time we get to court. I can guarantee my officers if they get in that witness box and they say something that I know is out and out false according to the evidence they've previously supplied and what I know, I will stop the court case then and there. I will stand up, make a motion to the magistrate, Your Honour, I wish to strike the matter out. If he asks why, I will tell him. I'll say, Your Honour, I've just become aware that this witness has given false evidence. I'll then take it up with the bosses back at the office. That's how serious I view the respect to court, and I would hope every officer there does the same thing. And the other point, magistrates remember. They don't forget. They're much like wives who get left off buses at conference dinners. They will not forget. You could be in court once in 6 months. You go back in 6 months' time. If you've done the wrong thing, they'll remember you. If you've done the right thing, they will remember you even more. So getting close to the end now, summing up, probably can be summed up in the 4 Ps. Be professional, be prepared, present well. It is about presentation as much as it is about the evidence. And the last one is practice. And this is something which a lot of people miss out on. If you don't have court, don't feel bad about talking to your manager supervisor saying, I've got court in a couple of weeks, can I go sit down in the local magistrate's court, get a feel for it and find out what the hell's going on? Just simply knowing where the courtrooms are, simply knowing where the clerk's going to be sitting, where the bar table is, where the magistrate is sitting, where the coat of arms is. Because in effect, when you enter a court, you're not bowing to the magistrate, you are bowing to that coat of arms. Things like that will help your day in court run smoothly and you'll get the best result. Organise or find out who can organise realistic mock court training. And I say realistic, we've all been to mock court training where it becomes a bit of a piss take towards the end of the day and people are in the witness box having a good old laugh at things. I'm in the process with another in-house counsel prosecutor in Melbourne of organising some in-house mock court stuff. And I can guarantee you if we sit down and we prepare that, we're going to be preparing cases where there's a hole in the case. And if the officer falls into the hole when they're giving evidence, we're going to go after them like it's no one's business. It will be very realistic. If nothing else, I can promise them it will be realistic. If you have an in-house counsel prosecutor, talk to them before court. Don't be the first time you meet your lawyer, your prosecutor, the day of court. If you have concerns, talk to them about it beforehand. If we hear about it beforehand, we can fix it. And to managers, supervisors in the room, we spend a lot of time giving staff training so that they don't get their arm ripped off when they're trying to catch the dangerous dog. We give them a lot of training to make sure the animal is handled correctly so they don't do their back, so the animal's welfare is taken care of. You also need to dedicate serious training, thought and time to this area of the process. The last thing you want is to have a dog attack case which has been dealt with beautifully and all the training provided has got you to court and to have it fall over at the last minute. That is the worst thing that can happen. I've seen it happen and I've seen the effect it has on officers. So to the managers and supervisors in the room, please dedicate serious time, please dedicate serious money if you need to make sure your officers are well prepared in court before they get there. A well-prepared officer will give you a better result every time. You never want to see that. That look on that face I have seen in real life on magistrates looking at officers, at that time I want to crawl under the bar table and hide. The witness box is a very lonely place if you get stuck there and you're seeing that look on your face. But if you go with the 4 Ps and remember the golden rule of respect, you won't get that. You will have better results in court and it won't be a situation that gives you stress ulcers every time you hear that you have to go there. And that's the end.